He's going to come around for the donations. Okay. Okay, we're back on. So when he went into that sentencing hearing, he had done everything correctly. Now, he was up in front of the judge, and he had told me before that this judge was very well noted in this county as being one of the sternest, meanest, orneriest judges that exist. And he said that when he had done the plea bargain, he noticed that the judge seemed to mellow, at least in his attitude toward him. Now remember, our hero here has been fighting this whole process for a year and a half or more, and so he was well familiar to a certain extent with this judge. Now, after he had done his allocution statement, the judge looked at our hero and he said the following to this man. He said something like, "It appears as though there has been 1 or 2 felony convictions in the past. If you can show me where you are not the person sentenced in the last felony charge in this state, I will not have to sentence you to a mandatory prison sentence under the statutes." Then the judge shut up. And our hero got to think about what the judge had just stated and respond to that judge. Well, our hero has only been studying this process for approximately 4 weeks. And there's absolutely no way that you can take a student through all the possibilities of response and existence that can happen in 4 weeks. And so our hero looked at the judge and he said to the judge, "I have accepted the offer for value, I have returned it for value, and I have asked for settlement and closure." How many times have we heard patriots make those statements in the court? As though, hey, I'm cool, I just did everything I needed to do. The judge looked at him and said, "Do you have anything else to say?" And he basically said no. The judge then looked at the prosecutor and the defendant's attorney and said, "It would appear as though there is no constitutional issue in front of this court." Then he sentenced our hero to the 5-year statutory minimum sentence based on the facts in front of the court that there had been a previous conviction for a felony, and our hero had not rebutted the presumption that the defendant, i.e. the 15-year-old evil son, and the living man standing in front of the judge were not one and the same. Remember, the judge said to him, "If you can show me where you are not the person sentenced to the previous felony conviction, I will not have to sentence you to a mandatory 5-year prison sentence. Now, there are many people out here in Never Never Land that believe that this whole concept of you and your straw man being two entirely different entities is an illusion. It's stupid. It's not real. But this judge was basically, in a colorable manner, saying to this guy standing there for sentencing, if you can show me where you, the straw man, are not the same person, I don't have to put the responsible party into jail. What more evidence can you have of what's going on? This guy had done everything correctly up until then. I'm sure the judge behind the scenes was smiling, going, gee, I wonder if he really knows this, if he can pull it off. If he doesn't know what he's doing and he doesn't pull it off, then that's his problem. I'm just the referee. Okay, so what ended up happening is our friend got sentenced, and I had been telling him for all 4 weeks that I was tutoring him that it was very critical that he get his UCC-1s filed with the Secretary of State in his case. And in reality, he had more than enough on his plate to deal with. It wasn't like he didn't understand the issue. It's not like he didn't want to file. It's like, well, I've got 4 weeks and I have so much to do that I just have to do what I have to do. Now, the real purpose of the UCC-1 filing is that it creates the evidence, literally, that there are two separate persons legally there. So the judge could just as well have been saying to our friend, all you need to do is bring forth any kind of additional facts. Remember what Lee was telling you with respect to the people he's been tutoring when it comes to this concept of probation? You have to accept their offer, return their offer, add some additional facts, and ask for settlement and closure. The judge, in textbook fashion, said, I've seen all the honor that you've been demonstrating here. Your procedure is immaculate. In form, this is one of the most fantastic turnarounds I've seen in a case. But remember, you have to have a double witness, one from column A, one from column B. Column A was the form demonstrating that he was in honor. Column B was from substance, and on the substance side, you've got to put evidence of a fact into this tribunal to rebut a presumption of a fact which is only assumed and presumed. The Equity Admiralty Court assumes and presumes that if the defendant was in dishonor, the offender will also be in dishonor because the offender operates the defendant. And there's also a presumption on the substantive side that if the defendant has created a substantive damage or breach, that the offender also might create that breach or that damage. The judge was just saying to our friend, you have met your obligation in form in terms of your sentencing allocution. If you can bring forth any evidence as to the separation of the two parties, the offender and the defender, then I can ignore the statutes because you are removing my presumption from public to private. But if you cannot rebut this presumption with any evidence and facts, then I have no alternative but to carry out the public presumptions. In essence, he was saying, yes, and do you have your UCC-1 or any third-party evidence of the separation of the parties? Our hero neither understood the question, nor had he sufficiently created the evidence to rebut the presumption to displace the public assumptions that the judge proceeded with. The judge, having no ammunition, i.e. no facts to rebut the presumption, had no alternative but to apply the public judgment. Everybody in the patriot community is out there looking for where is the law. There is no public law. Oh, sure, we have the statutes, we have the regulations, we have the acts of the legislature, we have the administrative codes, but those are mere assumptions and presumptions of a law which do not exist because the public is in a receivership and has no capacity to execute law without your consent. All the patriots are saying, show me where there is a law involving a duty to pay a tax. It doesn't exist. Well, it does exist by contract when you acknowledge they don't have a law and want to argue it. It becomes the contract between you and the public in your case. And the law by which you're executed is the law of dishonor by arguing with your brother on a law that we all know does not exist. And the interesting aspect is you're sentenced based on a dishonor for arguing a law which doesn't exist. Had you not argued the law which didn't exist, they wouldn't have executed against you and you wouldn't be in prison because we all know the law doesn't exist. Remember what we read at the start of today's meeting? That little poem or that little ditty from Alice in Wonderland? But I don't want to go among crazy people, Alice remarked. Oh, you can't help that, said the cat. We're all crazy here. I'm crazy, and so are you. How do you know I'm crazy, said Alice. You must be, said the cat, or you wouldn't have come here to argue our non-existent laws with us. Isn't that what they're telling you? Joe, you have a comment?
Yes. I get so sick and tired of being in dishonor. When do we hold them in dishonor? Now, if there is no law and they charge us with no law, aren't they in dishonor? And shouldn't they have to jump through all these hoops and we just sit back and say,
When is the teacher in dishonor when she's trying to teach her class?
Who says they're the teacher?
Haven't you understood that Merovingian says that we've been placed here as the custodian of the truth? And we're here to teach you.
Merovingian may not be included in my case.
Well, his agent is there. And in Scripture, the Father said, you would not listen to my prophets and my priests, so I've sent you your enemies to teach you. That's who they are.
Just seems like they're in dishonor for even initiating these cases, but I don't know how to...
Absolutely, it's all a test. Let me explain to you, I was supposed to be here early tonight, and as usual I was late, but then everybody knows I'm going to be late anyway. The only question is, how, right? Like the Indians said. I was talking to some gentlemen up in Canada. Very, very interesting little caper. About 5, 6, 7 years ago, a gentleman up there was an agent to sell some TV decoder boards for satellite downlinks to people in Mexico and the Caribbean. And he actually, for a period of time, set up a little group and worked with some people, and they purchased legally, lawfully manufactured decoder boards from sources in the United States which built these decoder boards for these television downlink receivers. And then they set up, by word of mouth and other sources, people in Mexico and the Caribbean that wanted to purchase these decoder boards to add to their televisions. And lo and behold, when they did, they were able to view satellite TV, which was available to people all over the United States on a subscription basis. Now, it's about 7, 8, 9 years after the fact, and these guys, we were in business for a little while, then kind of went out of business by 97, 98. This gentleman was in Canada. Now, what happened is some of the satellite interests in the United States lodged a complaint with the FBI and the IRS and other U.S. law enforcement groups and said, we want you to prosecute these people. What are you going to prosecute these people for? Stealing satellite images without compensation. Very, very interesting, though. The satellite programming was licensed for operation in the United States. There were no licenses for service to areas like Mexico, Caribbean, even Canada at that time. These guys were buying legally manufactured boards, and they were selling them to people outside the service area for which the services were licensed. Now, in the United States Criminal Statute Code, the wording comes down that says that you're not allowed to manufacture, process, distribute, sell, whatever, for the purpose of getting customers or allowing customers to access this television programming without paying their lawful charges. The people in Mexico and the Caribbean are paying no charges. Why are they paying no charges? Very simply because the satellite people are not licensed to provide the services in those areas. And these people, at least some of them from time to time, have written to the United States and said, how much do we pay for receiving your television program? And they either get no answer, or the answer is, I'm sorry, we cannot send you a rate schedule for the services in your area because we're not licensed to provide them. So what is the lawful fee for picking up these services in those areas? Probably zero. Now, they attempted to bring criminal charges against this guy up in Canada for racketeering, corruption, for money laundering, because all of the fees they collected, not for charging for the programming service, they couldn't do that. They just charged to supply the hardware to people in a country or in an area in which there was no licensing, no servicing or anything, but they could just, get the receiving signals notwithstanding. Now, in Canada, you've probably heard of this Echelon project where they say the CIA and FBI is snooping against Americans that are online, telephones and radios and everything else. Well, the reality is that bank of radio receivers is in Canada intercepting United States messages. And there is no law that Canadians can't intercept U.S. radio messages, and the Canadian government or the people intercepting them in Canada can do whatever they want with them because there's no law in Canada protecting American communications that are picked up by radio receivers in Canada. Now the issue is, and a lot of times there's plenty of Supreme Court cases that have said that if it's transmitted so that people can pick up the signals and you haven't encoded it or done whatever with it to keep it private, that as far as it's concerned, it's a public transmission and it's not protected by private right. So I asked this guy in Canada, I said, to your knowledge, is there any treaty to which Canada, Mexico, and the other countries have now gotten into that says that they cannot intercept satellite transmissions from the United States and use them for whatever private purposes they want up there? And he said to his knowledge he has no notice that any of that law exists. Now, the United States, well, first of all, the U.S. public satellite interests went to Canada and brought a suit in Canada against this guy a couple of years ago, charging him with crimes in Canada. And the interesting thing is there is no extradition from Canada to another country unless there is a criminal law in Canada, like the criminal law in the country to which you're being extradited to. They can't extradite you unless it's a crime in Canada for what they're taking you back to the other country to charge you with. Now, since there was absolutely no satellite downlink treaties or services in Canada at the time this was going on, there were no laws in Canada making it criminal. Therefore, the Canadian courts threw the criminal charges out against this guy in Canada. And the companies in America went home with their tail between their legs, really ticked off, how are we going to get this guy? Now what happened is there is plenty of court cases in Canada dealing with extradition. And the appellate courts in Canada have ruled on extradition for criminal offenses against Canadian citizens by foreigners for years and years and decades. And all of the appellate court decisions basically held strongly that when the United States tried to come up there and extradite Canadians for criminal law violations in this country, there was almost zero extraditions totally of anybody from Canada to the United States because of the interpretations in the what he called constitutional protections of the Canadian Constitution or documents. Up until about 2 years ago, when the Canadian Supreme Court overruled all of those appellate cases in a new case. And they said that basically extradition could occur without all the quote-unquote constitutional protections that had existed by assumption and presumption of all these previous court cases that were appealed through appellate courts in Canada, but actually never went to the Canadian Supreme Court. Now, this guy has got an attorney that says he's a constitutional genius, and he wants to lose this case of extradition at the lower court to take it up to the Canadian Supreme Court on constitutionally protected grounds based on what the United States wants to do and extradite this Canadian citizen and bring him into the United States for violation of the so-called use or sales of equipment for getting your television download off the satellites without paying your lawful charge. And I said, you know, if you go back and take a look at that Canadian Supreme Court decision, I will bet you dollars to donuts. It came out after one of these latest so-called NAFTA treaties. And you will find out now that the commercial link that those treaties have created between the two nations have set aside the personal constitutional issues based on the fact that all constitutions must accept all treaties as the highest law of the land, and they cannot rebut the presumption that the treaties are not valid because of a constitutional limitation. So I said, it sounds to me like a put-up that basically what they're telling you is since all these treaties have united all of North and Central America, that there are no more limitations. And this gentleman said, oh yes, and all the affidavits are not sworn to, and they're all hearsay, but even my attorney says, well, we're not going to be able to rebut that or go against that in terms of prohibiting the United States from extraditing you. And so these guys in Canada became interested in what we're talking about on our Monday nights. The acceptance, the return, the rebuttal of the false assumptions and presumptions. And I said, here is your crazy attorney, and he's fighting in terms of procedure. He may as well be fighting in terms of the merits. He's just making them angry and wasting everyone's time. It sounds to me like the easiest rebuttal of everything that's going on is to rebut the assumption and presumption that the end users did not pay any lawful charges. And if the statute or the law particularly requires that it's to prevent the collection of lawful charges, just accept everything and then add additional facts into your negative averment that we requested to find out what the lawful charges were in these areas, and at no time were we ever given notice of the charges. And then furthermore, rebut the presumption. I said, well, you guys, they know, FBI and the IRS knows You were purchasing these boards in the United States. And said, oh yeah. How do you know that they're not assuming and presuming you sold some of these boards to U.S. resident citizens, causing the problem that they're arguing about? Have you ever done a negative averment that none of these boards were ever sold in the geographical area of the United States? He said, nope, nobody's ever done that. I said, let me get this straight. This is at least your second or third trial. There was a civil, a criminal in Canada, and this is an extradition for a criminal in the United States. And you people have not even done an acceptance of the fact and a rebuttal of the presumptions by a negative averment. Is that correct? He said, that's correct. I said, all you people are doing is delaying the inevitable, creating more dishonor. I said, what in the world is your attorney doing? He said, well, he's arguing now that since all of these actions occurred in 96 and 97 and 98, and the Supreme Court of Canada ruled on their case in like 2001 saying it was illegal, my attorney is saying, but it wasn't illegal in 96, 97, and 98 in Canada. And under the Canadian extradition, if it wasn't illegal in Canada, they can't extradite. That's what my attorney is saying. I said, wait a minute, time out, hold it. Did Parliament in Canada change the law between the time you were involved in your business of board sales and the time that the Supreme Court ruled on the legality of that case? He said, no, there hasn't been a change of law in years. I said, does the court have the authority to make law? The answer is absolutely not. It doesn't make law. It passes on the legality or lawfulness of acts. I said then in 2001, the Supreme Court of Canada made a decision that whatever the issue was, that it was illegal the way people had been doing it. He said, that's correct. I said, if it was illegal by a decision of the Supreme Court in 2001, when was that behavior illegal? All the way back to the time the law was passed, whenever anyone interpreted it in that manner. Therefore, if you were doing it that way in 96, 97, and 98, it was just as illegal then as it was when the Supreme Court of Canada told you it was illegal in 2001. They didn't change the law, they ruled on the law. Therefore, your crazy attorney's argument that you assumed it was legal back then is stupidity. What is he trying to do? Drag this thing out to make a living or a name at it? Let's deal with what we need to deal with to get settlement and closure. Now, Joe said, when are we going to get these people for their dishonor against us? Excuse me, dishonor is nothing more than assumptions and presumptions to which it's not dishonorable if you want to agree that the assumptions and presumptions are true. It's not a dishonorable act. It's getting an agreement of the parties so we can proceed. So these people throw out a lot of assumptions and presumptions, and then they see whether A, you agree with them, and B, what procedure you go through if you do not. Their solicitation into accepting assumptions and presumptions is merely an offer. It's not fraud. It's not a dishonorable act. But in commerce, it could certainly be a calculated event to try to trap you into some kind of liability that later on you certainly may regret if you don't understand what's happening. So who is it that's dishonorable or fraudulent in this case? Is it our friend who doesn't understand what he's involved in and doesn't know the procedure so that he can play the game well enough to protect himself? Is it the U.S. satellite interests that are trying to maximize their profits? Is it the United States IRS and FBI that make a living by charging people with assumptions and presumptions of criminal acts? Is it the lawyer for our hero up in Canada who makes his living by going to commercial warfare in your behalf? He's just a paid soldier. And as long as you don't give him guidance and direction and want to pay him to carry out your war for you, he'll do it all day and all night and go to the bank with the profits. It's just a bunch of competing interests in commerce that are soliciting you to see if they can make a revenue off of you. It's a test. What part of your activity in your life do you not understand you're involved with? What part of the people who solicit you and make a living off of you are you not supporting either by your intentions or your ignorance? It all comes back to you. It comes back to understanding who you are, who they are, what you are involved with, what your duties are, what your benefits are, and what your responsibilities are. It's nothing but a game. Don't take it seriously unless, of course, you're confused by the game, by who you are and what your role is in it. So the concept is, know yourself, know your enemy, and know how to play the game. That's what it's all about. And everything else is just a test to see whether you know yourself, know your enemy, or know the game. Now, our hero back there in New York basically had an opportunity to demonstrate that not only could he be procedurally in honor, but he could answer the riddle, am I separate from the defendant who was convicted? Now, he didn't answer that question, and when the judge said, I guess there is no constitutional issue, we know that the Constitution contains two venues, public and private. So when the judge said, it appears as though there is no constitutional issue, what was the judge saying in code? There's no separation of a public and private interest here. It appears as though only the public has showed up and appeared in the sentencing. Thereby, I can carry out the sentence pursuant to public policy, which is the statutes and the regulations and the report on sentencing. There is no private interest here. Now, when our hero went into the plea bargain agreement, as one of the terms and conditions of the plea bargain agreement, the court said, if you enter into the plea bargain agreement, you are going to agree never to appeal this decision. You waive your right of appeal. Is there anything wrong with this? Well, it's an offer, yes. You don't want to argue the offer. If you understand the public and private business and you're trying to settle it, why would you appeal? An appeal isn't a settlement. It's more warfare. So the court said, we understand what you're trying to do. Settle it. So you agree you won't appeal it, right? Well, he agreed not to appeal it. Now, once the court said, you're going to jail now for 5 years under the public, his attorney looks at his client and he said, if I were you, I would immediately file an appeal. Create more warfare, yes. The attorney, though, said to him, you cannot appeal the case, but you are free to appeal the lack of representation of a competent attorney. That's all you can appeal. Tell you something? Remember when we were drafting the attorneys, put this, and the next thing into the public record? If they don't do that, and you don't screw up, they're liable. Now, if you appealed on the lack of a competent representation, what's your evidence? All your letter rogatories and the lack of any filings in the court. And not only have you sent them to the attorney, you sent them to the judge and you sent them to the prosecutor. Now understand this. When the judge said to our hero, if you can show you're not the person, he could just as well have been speaking to this guy's lawyer as he might have been speaking to the principal himself. In which case, an appeal based on lack of competent representation might just vacate that sentencing, giving the judge the out. The judge announced publicly in the court that he was looking for something, and then the judge said, there is no constitutional issue. Hello, where is this guy's lawyer? Well, he had sent the lawyer letters rogatory, and none of the documents ever appeared in the court. Now, I'm saying that our hero screwed up, but I'm also saying that the lawyer had notice of what he was supposed to be doing to help. After all, didn't the court appoint him to help? Where the hell is he? See, the court represents the public and the private. And the lawyer represents both the public and the private. If you've attorned him, here is this guy's own attorney telling his client to appeal on attorney incompetence. Now, there's an attorney. There's a lawyer. And that lawyer was responsible to his client, wasn't he? Because the lawyer could have been saying, if you have ears to hear and eyes to see, all of this public thing did everything that the public thing did, and you're going to jail right now. You want to get out of there? Let's correct it. It'll be page 29 6 months from now, and nobody's going to give a hoot. If you have eyes to see and ears to hear. All this is a new offer, a new test. Do you understand what we're learning? Now, here's my friend. They immediately take him off and put him in jail. It's a shame that our lady hero isn't with us tonight because she's an expert at jail.